Hey guys, it's Anthony Bandiero here with Blue to Gold Law Enforcement Training, and we're doing another roadside chat, and this one is a legit roadside chat. I am on the road in Baton Rouge, Louisiana, having a great time teaching at the Louisiana District Attorneys Association, and a lot of great cops are here, and it's a great conversation, so it's good to be back on the road, right? So here's a question that came up. Somebody wants clarification on protective sweeps of a vehicle for weapons when the person has no realistic opportunity to access a weapon. They are pulled away from the car, they're not in the lunge area, maybe they're in handcuffs and so forth. And I get it, if you read case law on it, it's kind of all over the map. But let me share with you what's going on, right? What I think is really what the courts are looking for here. So first of all, I separate these in two categories. The first category is when you have a detention of a motorist, passenger, and so forth, and you have reasonable suspicion that they may be armed and dangerous, right? So you pat them down, and you then want to do a protective sweep of the car. The courts are looking for some ability to access the car, right? So if the person is in handcuffs and controlled, and you're still sweeping the car, it's problematic. But one thing I have seen is that some officers are articulating that, okay, I get that he's not able to access the vehicle right here, right now. But at this point, he is going to be released. We're not sure. It's still a reasonable suspicion. We don't have probable cause. It's not like he is going to jail. So he could get back into that car and leave. And I have seen courts buy that argument, and it's somewhat persuasive, right? I mean, if at this point he's temporarily detained and he could get access later to the car, you could still have a dangerous person with a weapon. So there's that, all right? So the first rule is that if you have reasonable suspicion that he's armed and dangerous, and you're not positive there's a weapon in the car, and there's some legitimate access now or in the future, courts will uphold it. Otherwise, they'll give you a hard time if those two things are not in place. Well, then there's the other situation where cops, have more concrete knowledge that there is a gun in the car, right? It's a drive-by shooting suspect and so forth. And it may still be reasonable suspicion. If it's probable cause, then we have no issue because that's the motor vehicle exception. That weapon would be evidence, right? Most likely of a crime. But those cases are almost overwhelmingly in the cop's favor, whether the guy is in handcuffs, even in the back of the car, and so forth. They just want that gun to be secured, right? Other people could grab the gun. It's a chaotic scene usually in these cases. So my advice on that is if you have a pretty good evidence, that strong reasonable suspicion, I guess you'd say, that there is a gun in that car, the courts again will overwhelmingly allow you to secure it. Otherwise, we're back to the other one, which is your typical Terry, reasonable suspicion where you have facts and circumstances to believe that the person could be armed and dangerous. Well, then they're going to want some kind of lunge area access. Wow. Clear as mud? Well, hopefully a tad clearer, if anything, and we move the ball forward, right? These roadside chats are just conversations. We're not talking about specific case laws in each state. We're just talking about what I believe the courts are looking for. And they're great conversations. I hope you enjoy them. Keep the questions coming. If you have more questions, let me know on at info@bluetogold.com. Until next time, stay safe.
When it comes to legal training, we're the gold standard. Visit bluetogold.com or call 888-579-7796 today to purchase the Search and Seizure Survival Guide, register for a class, or learn how to bring our search and seizure training to your agency.